AITA for exposing my wife in divorce court after she secretly cut my health insurance? I am 41 years old right now. This story begins 2 years ago and ends 4 months ago with the signing of some documents at a notary public that closed 8 years of marriage and opened something I am still learning to name. It is not a story of hate, because hate requires an energy that I decided to use in another direction. It is a story about what happens when someone makes a decision they believe will have no consequences, and then discovers that consequences have a very good memory and a lot of patience. To understand why what happened was what it was, I first need to explain what kind of marriage Laura and I had built over 8 years, and at what exact point that marriage was when what happened occurred. My name is Brian Mitchell. I am an IT systems engineer. I work at a technology infrastructure company, and I have a relationship with problems that is methodical before being emotional. When something fails, the first thing I do is gather information. The second is to understand the pattern. The third is to act with complete information instead of acting with partial information. That produces consistent results at work. In our marriage, it was sometimes the source of friction because Laura needed me to respond emotionally at the exact moment she needed that response. And I often arrived late to that moment because I was processing. Laura is 39 years old. She is a marketing director at a large consumer products company, intelligent in a way that is immediately noticeable, with an ability to read situations and people that was a valuable tool in her job. She was charming in the most technical sense of that word, the kind of person who makes anyone in the room feel like they are the most interesting. She also had, and I only understood this clearly toward the end, a relationship with control that in the good years of the marriage was invisible because she did not need to exercise it, but which in the difficult years became the central element of how she handled uncertainty. We met when I was 31 and she was 29 at a professional networking event we had both gone to with the low expectations one brings to those events after attending them for a while. We talked for 40 minutes about technology and digital marketing, which was an area where our professions overlapped. And at the end of the event, she asked for my card with the naturalness of someone who knows what she wants. We dated for 2.5 years, and we got married. The first 5 years were what one would expect from two people with demanding careers and strong personalities building a shared life, good with the normal ups and downs, solid on the fundamentals, with manageable frictions that we either resolved or learned to live with. In the 6th year, something began to change that neither of us knew how to name properly at the time, because when you are inside something that changes gradually, it is difficult to see the full shape of the change. I had had a very intense period of work, a major system migration project for a large client that had taken 8 months of my life in a way that, in hindsight, was excessive, but which at the time I justified with the importance of the project and the kind of results it would produce. I got home late. I worked weekends. I was physically present at our apartment, but mentally somewhere else. Laura had tolerated it with the patience of someone who understands that projects have phases and that phases end. But when the project ended and I did not completely return to the marriage with the speed she expected, that patience turned into something else. The conversations began about presence and absence, about priorities, about whether I really saw her or simply shared the space with her. She was partly right. I recognized it then and I recognize it now. I had been absent in a way that had left Laura carrying more than what was fair. But the way she communicated it, with an intensity that escalated rapidly when I did not respond with the same intensity, generated a shut-down response in me that was the exact opposite of what she needed. That is how we reached the period I internally call the 4 gray months. For months where we shared the apartment, ate dinner together most nights, slept in the same bed, and yet the marriage was suspended in a low-temperature zone that neither of us knew how to resolve without the solution requiring more energy than either of us had available at that moment. We had not talked about separation explicitly, but the topic floated in the air with the specific density of something that exists, even if nobody names it. It was during that period that Laura made the decision. We had our health insurance through Laura's company since the 3rd year of our marriage. Her company offered a corporate plan that covered the employee and their spouse with significantly better conditions than the plan mine offered. The decision to use her plan had been completely rational. One of those practical decisions couples make when they evaluate options and choose the best one without any emotional component in the choice. How it worked was simple. Laura was the primary policyholder of the plan. I was the dependent. Any modification to the plan required her authorization as the policyholder with her company's human resources department. I had no direct access to the plan's administration, I did not receive notifications of changes, and I had no reason to check it regularly, because it was something we had agreed upon, and it had been working for 5 years without any issues. That meant that if someone decided to modify it, I would not find out unless I needed to use it. The incident happened on a Tuesday morning at 8:15. I was leaving home for work. I was walking down the stairs of our apartment building with my phone in my hand, checking an email that had arrived late the night before about a change of requirements in a project. I was not running. I was not distracted in a way that justified what happened. There was simply a step on the final flight of stairs that had had a loose screw for weeks, which the building superintendent had promised to fix on 3 different occasions during the previous month without any of those promises turning into action. That Tuesday, the screw gave way completely when my right foot stepped on it at the wrong angle. The fall was sideways toward the wall of the stairwell. The impact was against the right side of my body. I felt the unmistakable sign of a serious injury, and the intense pain that followed left no room for any other thought. It was not the pain of a hard hit. It was the kind the body registers as urgent. I stayed on the floor of the landing, unable to get up. The first-floor neighbor, a man in his 60s named George Peterson, who was leaving for work at the same time, found me there. Without asking too much, he called 911 and stayed with me until the ambulance arrived, which took 9 minutes that felt much longer. The paramedics were efficient. They immobilized me, put me on the stretcher, and took me to the nearest hospital with a speed indicating that what they described as a possible rib injury required rapid verification. I arrived at the emergency room of Memorial Hospital at 8:42 in the morning. The emergency room of that hospital had the specific energy of a Tuesday morning, which is different from the energy of a Friday night, but which has its own intensity. There was staff moving with the efficiency of someone who has done this thousands of times, and patients in different stages of whatever had brought them there. They put me in an evaluation room. They took x-rays with the care necessary for someone who possibly had chest injuries. The doctor who treated me was named Dr. Robert Harlan, a man in his 50s with glasses he had had to adjust 3 times during the evaluation, and the tired patience of someone who has been on call for many hours but still listens closely. The diagnosis arrived 40 minutes after my admission. 3 fractured ribs on the right side. Ribs 4, 5, and 6, with a pattern that required observation because depending on how they settled in the following hours, there could be additional implications. In addition, a significant contusion on the right shoulder and a sprained left ankle that in any other circumstance would have been the main injury, but which next to the ribs was comparatively minor. Dr. Robert Harlan told me I was going to need hospitalization for at least 48 hours, that the pain was going to be manageable with medication but was not going to disappear quickly, that complete recovery would take between 6 and 8 weeks, and that during that time there would be activities I simply could not do. He told me this in the direct manner of someone who has delivered that kind of news many times and knows that clarity is more useful than softening it. I told him I understood and asked what was next. He told me the first thing was the administrative admission process, and then we would start with the treatment. The nurse processing the admission was named Karen Mills, according to her badge. She was efficient and kind, with the specific combination of people who do that job well. She asked for my name, driver's license, and contact details. Then she asked about my health insurance. I gave her the policy number I had memorized. It was a number I had used 2 years prior for a preventive checkup Laura and I had done at the same hospital, and for some reason, important numbers tend to stick. Nurse Karen Mills typed into her system. She waited. She typed something else. She waited again. Then she looked up with the specific expression of someone who is about to say something they do not want to say. She asked me if I had another policy number or any additional insurance documentation. I told her no, that was the number I had. She told me she was very sorry, that the policy number existed in the system and the primary policyholder appeared active, but that upon searching my information as a dependent, no active record linked to that policy appeared. I stared at her from the stretcher with 3 fractured ribs and the level of pain that entails when the medication has not yet reached its effective level. I asked her to verify it again. She verified it again with the same careful attention of someone who knows they are about to confirm something the other person does not want to hear. The result was the same. I called Laura from the emergency stretcher using the phone nurse Karen Mills had helped me take out of my pocket because moving too much was complicated at that moment. She answered on the second ring. I explained to her in the fewest possible words what had happened. The fall, the ribs, the hospital, the necessary hospitalization. Her first reaction was exactly what one would expect from someone who has just heard their husband is in the emergency room with serious injuries. Genuine alarm. Quick questions about how I was. The immediate declaration that she was on her way. Then I told her what Nurse Karen Mills had told me about the insurance. The silence that followed lasted approximately 4 seconds. 4 seconds is a long time on a phone call after urgent news. Then she said there must be an administrative error, that she would resolve it, not to worry about that now, that the important thing was for me to be okay. I told her I was worrying about it now because I was in the emergency room with 3 fractured ribs and needed to know if I had coverage for the hospitalization the doctor had told me was necessary. She told me to talk to the hospital administration, that she would immediately call her company's human resources to clear up the administrative error, and that they would resolve it before I needed to sign anything. I hung up. Nurse Karen Mills explained the process to me with the kindness of someone who understands that this was not what I needed that Tuesday morning. Without active verified coverage, I needed to sign a personal financial responsibility form to proceed with the admission. It was a standard process, she told me, which would be resolved with retroactive coverage if the insurance confirmed the coverage later. I signed what had to be signed. I had no other option, and it was also not the time to analyze the implications of what I was signing beyond what was immediately necessary. Laura arrived 43 minutes later. She arrived with the energy of someone who has come fast and is genuinely scared by what has happened to another person. She found me already settled in a 4th-floor room, with the medication working and a pain level that was manageable although constant. She approached, touched my hand, said she was very sorry, that she had spoken with human resources and they were reviewing the situation, that it should be resolved soon. I asked her with the calmness provided by pain medication when exactly the administrative error that dropped me from the insurance had occurred. She told me she was not sure about the details, that human resources was investigating it. I asked her if the error had occurred in the last 5 months. She looked at me for a moment that lasted long enough to be information in itself. Then she said it was not the time for that conversation, that I was in a hospital with serious injuries, and that the important thing now was my recovery. I told her she was right, that it was not the time, but there would be a time. I said it with no special emphasis. Like an observation on time management, I spent 47 hours in the hospital. Dr. Robert Harlan came by twice a day to check my progress. The fractures were in a stable position, which was the best that could be expected given the type of injury. He explained to me that fractured ribs heal on their own because there is not much to do surgically with them, that the treatment was primarily pain management, rest, and monitoring to ensure there were no complications, which were possibilities with that specific injury pattern. Laura came both afternoons. The visits had the specific texture of 2 people who have a pending conversation that neither is having yet. We talked about the incident, the recovery, the care I would need at home. We did not talk about the insurance. I did not mention it, and neither did she. That told me something. A genuine administrative error produces an urgency to resolve it in the person who discovers it. It generates calls, follow-ups, the need to close a problem that has a technical solution. What I saw in Laura during those visits was not the energy of someone actively managing the resolution of an error. It was the energy of someone hoping the issue would dissolve on its own. The day I left the hospital, Laura came to pick me up. In the car on the way back to our apartment, I told her that afternoon, when I was rested, I wanted to talk about the insurance. She said yes, whenever I wanted. That afternoon I was too tired. I left it for the next day. Before the conversation with Laura, I did what I do with any problem that requires complete information before acting. I called the insurance company from my personal phone. I provided my information and the policy number. The representative checked their system and confirmed to me, with the bureaucratic efficiency of someone reading data off a screen, that I had been covered under that policy from the 3rd year of our marriage until 5 months ago. The date on which I had been dropped as a dependent at the request of the primary policyholder. I asked if there was any notification that should have reached me when I was removed. He told me that notifications of changes to the plan went to the policyholder, not the dependent. that it was the standard policy for corporate plans. I asked if he could send me written confirmation of the coverage and cancellation dates. With the name of whoever had requested the modification, he said yes, that I could request it formally and would receive it in 2 to 3 business days. I requested it formally. Then I searched my bank statements for the last 5 months. There was a routine medical consultation I had postponed during that period because I did not have active insurance, and the out-of-pocket consultation cost what it cost at the time. It was an appointment I had decided to postpone and which was not urgent. I had finally gone the previous month, still without insurance, but because the minor symptoms I wanted to get checked had persisted long enough not to keep postponing. The result of that consultation had revealed a minor condition, nothing serious, but a condition that if detected 5 months earlier would have required a simpler and less expensive treatment than it required now that it had time to progress. I saved that piece of information. The insurance company document arrived 3 days later in my email. I printed it out, saved it along with the hospital bills, the summary of the delayed medical consultation and its cost implications, and a calculation I made regarding the approximate value of 5 months of medical coverage I should have had and did not have. I put it all in a folder. I kept the folder in my work briefcase, not at home. Then I had the conversation with Laura. It was 4 days after leaving the hospital. I had recovered enough to think clearly, although the pain remained a constant background fact. We sat in the living room of our apartment, the same one where we had spent the 4 gray months. With the afternoon light coming through the windows, I told her I had called the insurance company. Laura said nothing. I told her I had the confirmation document, that I had been removed from the plan 5 months ago at the request of the policyholder, that it had not been an administrative error. Laura looked out the window for a moment. Then she looked at me. She said that what she had done was a decision she had made during a very difficult time, that during those months she had thought perhaps the marriage had no future and had started taking some steps that at the time seemed necessary to her. That she had thought if things improved, she would correct it before it mattered. I asked her if at any point she had considered telling me she had dropped me. She told me she had thought about putting me back on the plan when the situation between us stabilized, that she had not anticipated there would be an incident. I asked her if the absence of an incident would have made the decision okay. She did not answer that question. I told her that what she had done had concrete implications that I was going to explain to her, that I had had to sign a personal financial responsibility form for a 2-day hospitalization, that I had postponed a medical consultation for 5 months because I had no coverage, and that this postponement had resulted in a condition that now required more treatment than it would have needed if treated on time. That all of this was documented. Laura said she was willing to cover the hospital expenses, that it was the least she could do. I told her that was a starting point. Then I told her I wanted us to talk about something more fundamental, that what I had discovered told me things about where we were that a conversation about insurance could not resolve, that I needed us both to be honest about whether this marriage was something either of us wanted to continue. Laura was silent for a while. Then she said that maybe we needed help to process everything that had happened. I told her I would think about it. I thought about it for 3 weeks. At the end of those 3 weeks, I told her I wanted a divorce. Update 1. The decision to divorce was not made in the heat of the moment or out of anger. It was the result of 3 weeks of thinking with the same methodology I apply to any complex problem. Gathering the complete information, understanding the pattern, arriving at the conclusion the information supports. The information I had was this. Laura had made a unilateral decision that had left me without medical coverage for 5 months without my knowledge. She had done it as a precautionary measure during a period of marital difficulty, which meant that at the marriage's moment of greatest vulnerability, her response had been to protect her own interests at the expense of mine. She had had 5 months to tell me what she had done, and she had not said it. And when I had discovered it in the emergency room, her first response had been the alibi of an administrative error. That pattern told me something about who Laura was when things got difficult, and what it told me was information I could not ignore. Laura received the decision with the composure of someone who had anticipated it. She told me she understood. She told me she hoped we could handle it in a civilized manner. She told me she did not want this to turn into a conflict. I told her I did not either, that my goal was to resolve this fairly and in an orderly way, and that I hoped hers was the same. She said yes. I contacted a lawyer that week. His name was attorney Stephen Brooks. He had been in family law for 22 years and had the reputation of being someone who preferred to resolve things, but who knew exactly when and how to escalate if necessary. A colleague who had gone through a similar process 2 years prior had recommended him, and his experience with attorney Stephen Brooks had been positive in the sense that the process had ended fairly without turning into what these processes can become when the parties decide to fight. I met with attorney Stephen Brooks a week after communicating my decision to Laura. I brought him the complete folder, the insurance company document, the hospital bills, the history of the delayed medical consultation and its cost implications, the calculation of the 5 months of unreceived coverage. I explained the context of the marriage, the 8 years, the difficult period, the exact timeline of what I had discovered and when. Attorney Stephen Brooks listened to me for 40 minutes almost without interrupting. When I finished, he reviewed the documents with the attention of someone who knows how to read what they are reading. Then he told me something I had not expected to hear in exactly those terms. He told me the insurance matter was not just an element of moral context. It was an element with potential legal relevance within the asset division process, because the unilateral removal of a spouse from a health insurance policy without notification or consent, when that spouse depended on that coverage and when the decision had produced economic impact, could be argued as a factor in the equitable distribution of marital assets in many states. He told me he could not guarantee the outcome because these things depended on many factors, but that the documentation I had was solid and the argument was legitimate. I told him I wanted to proceed. Update 2. The first formal negotiation meeting was 6 weeks after I communicated my decision to Laura. The meeting was in attorney Stephen Brooks's office, a meeting room on the 10th floor of a downtown building overlooking the city, which that day was covered in low clouds. We were 4 people, attorney Stephen Brooks and I on one side, Laura's lawyer and Laura on the other. Laura's lawyer was named attorney Melissa Grant, 40-something years old, gray suit. The specific efficiency of someone who has done this many times and knows that most of these processes have a predictable path. Laura was by her side with the composure of someone who has mentally prepared for this meeting for weeks. I arrived with the folder. Attorney Stephen Brooks opened the session describing the joint assets, the apartment we had bought together in the 4th year of our marriage, 2 cars, the joint savings account we had built over 8 years from 2 well-paid salaries, some investments we had made in the last 3 years. Attorney Melissa Grant presented Laura's initial position, an equal division of all joint assets. It was a clean, symmetrical proposal, the one anyone in Laura's position would have expected to be the starting point and possibly the ending point. Attorney Stephen Brooks said we had additional elements we needed to incorporate into the calculation before talking about percentages. Attorney Melissa Grant asked with the professional neutrality of someone who asks that question out of protocol, knowing the answer is going to complicate things. What elements? Attorney Stephen Brooks opened the folder and placed the documents on the table in the order we had prepared. First, the official insurance document with the exact coverage and cancellation dates and the name of who had requested the modification. Second, the full hospital bills with the total for the hospitalization, treatment, and medication. Third, the report from the delayed medical consultation with the doctor's note on the condition's progression during the period without care, and the comparative calculation of the cost of timely treatment versus the cost of late treatment. Fourth, the calculation of the 5 months of medical coverage I had been entitled to and had not received. Attorney Melissa Grant reviewed the documents with the attention of someone who knows that what she has in her hands is going to require a response she had not prepared for this meeting. Laura looked at the documents with the expression of someone seeing something materialize that she had hoped would not reach this point. I said nothing. I looked toward the low clouds over the city and waited. Attorney Melissa Grant said that the relevance of that material in the context of asset division was questionable from a legal standpoint and could be argued in different ways depending on the interpretative framework. Attorney Stephen Brooks said he completely agreed that it could be argued in different ways and that he was willing to have that debate in whatever framework was necessary, including if that meant the process became more formal, longer, and more public than both parties would probably prefer. He took a brief pause. Then he said his client simply wanted the calculation to be fair and to reflect the complete reality of what had occurred during the marriage, and in particular during the last months. Attorney Melissa Grant asked for a 20-minute recess. I spent the 20 minutes with Attorney Stephen Brooks in his office, which was next to the meeting room. He asked me how I was doing. I told him I was fine. He asked if I wanted water. I said yes. He explained that the recess was the clearest sign that the other side was recalculating, that if they had had a ready answer, they would have given it in the room, that the time they needed for that recess was proportional to how much they had to adjust their calculations. They took 17 of the 20 minutes. When we returned to the room, Attorney Melissa Grant had a new proposal. It was different on 4 specific points. Laura would cover the entirety of the medical expenses from the incident and the treatment of the late detected condition, which added up to a concrete amount that would be documented in the agreement. Laura would assume 60% of the pending mortgage debt on the apartment we were going to sell instead of 50% from the original proposal. The distribution of the joint savings account would be adjusted to 60 and 40 in my favor instead of the original 50 and 50. And Laura would waive any claim to the work equipment and tools I had acquired during the marriage, some of which had significant value. It was not everything I could have asked for if I had decided to make the process more extensive and more public. It was sufficiently more than the original proposal to represent a concrete acknowledgement that the folder we had put on the table carried real weight. Attorney Stephen Brooks looked at me with the implicit question of someone who has done his job and awaits his client's decision. I told him quietly that it was acceptable. Attorney Stephen Brooks communicated this to Attorney Melissa Grant. The preliminary terms were signed that same afternoon. Update 3. The formal divorce process took 4 months from that first meeting to the final signature. It was not a conflictive process once the main terms were agreed upon because neither party had an interest in prolonging it more than necessary. It was the kind of slow, bureaucratic process these processes have, regardless of the moods between the parties, with their deadlines and documents and verifications the system requires. Laura and I had no significant conversations during those 4 months beyond what was necessary for the legal process. We saw each other at meetings with the lawyers and on the occasional instance to coordinate practical matters regarding the apartment. We were courteous in the way 2 people are who have a shared history and who have decided that history does not need to be destroyed in order to end. The exception was a call Laura made on a Sunday afternoon, 3 months before the final signing. I answered because there was an ongoing legal process and it was reasonable to answer. She told me she wanted to apologize. Not for the divorce, which she said she understood even if it hurt, but specifically for the insurance. She told me it had been a decision made out of fear and from a place of a lot of pain, that at the time she felt she needed to protect herself from something, but that she had not thought about the real consequences for me. That when the incident happened and she heard I had no coverage, she had understood in a way she had not anticipated what her decision had produced, that she had carried it ever since. I listened to her without interrupting until she finished. Then I told her I appreciated her saying it, that I held no grudge, because resentment was not an emotion I found useful for anyone, including myself, that what she had done had real consequences that had affected my health and my finances, and that it was right for that to be reflected in the resolution of the process, and that it had been. She told me she understood, that she hoped I would be okay. I told her I hoped the same for her, and I meant it seriously, because the desire for something bad to happen to Laura was not an emotion I had. What I had was clarity about who she was and what she had done, and that clarity was enough. We hung up. Attorney Stephen Brooks had told me at some point in the process that in his experience, divorces that ended in an orderly fashion without turning into wars of attrition produced better emotional results in the long run for both parties, regardless of how the marriage had been. That the difference between resolving and fighting was not the amount of pain, but the form that pain took and the time it occupied in each person's life. It seemed to me an observation that was worth more than what it cost to hear it. Update 4. The signing was on a Tuesday morning, exactly 2 years and 3 days after the incident on the stairs. I do not know if that calendar coincidence was accidental or if Attorney Stephen Brooks had noticed it and left it that way without mentioning it to me. In any case, it seemed like the kind of detail one only notices when it is already over. We were 4 people in the notary's office: Laura, her lawyer, Attorney Stephen Brooks, and I. The notary was an older man with an impersonal efficiency, which was exactly what that moment required. He read the full terms of the agreement with the voice of someone who has read that type of document hundreds of times and who knows that what matters is that everything is on the record and that the parties confirm it. Laura and I signed separately. When we finished signing, we looked at each other briefly. There was no hug, no handshake, and no closing words. There was a nod from two people who have ended something and who do not know exactly what the protocol is for that moment, because nobody teaches you what the end of 8 years looks like. I left the notary at 11:15 on a Tuesday. Attorney Stephen Brooks shook my hand outside the building and told me it had been a difficult process handled with a lot of intelligence. I thanked him. We said goodbye. I went to get a coffee alone at a coffee shop on the corner. I sat down, ordered a latte, and watched the street for a while without thinking of anything specific. For months have passed since that Tuesday. The apartment sold 6 weeks after the signing. The process was faster than I expected because the market was good and the location was good. I have a rented apartment now while I decide without rushing what I want to do about where to live long term. It is smaller than the apartment, but it has something the apartment did not have toward the end, which is that every decision about it is made by me alone. The step on the stairs of the previous building was finally fixed, according to what George Peterson informed me on one of the last days I saw him before moving out. He told me this with the seriousness of someone who considered that information relevant to me. I told him I was glad. That better late than never, although I wished it had been sooner. I have new health insurance. I purchased it the same day I signed the divorce papers, in the afternoon, from my computer. I chose it myself after comparing 3 options. It is in my name as the primary policyholder and as the beneficiary. I receive every notification, every update, every communication directly to my email. The first time one of those notifications arrived, I read it with an attention that those types of routine emails normally do not receive. I heard nothing from Laura after the signing. I did not seek it out, and it did not arrive. That is also fine. There are 3 things I learned from all this. The first is that documentation has a value that goes beyond the use you make of it at the moment you build it. When I asked the insurance company for the coverage history, I did not know for sure what I was going to need it for. I asked for it because I had incomplete information about something that affected me directly, and I wanted to have it complete. That folder I built during my recovery with 3 fractured ribs was what determined the character of the divorce negotiation, because there is a fundamental difference between an injustice you know occurred and an injustice that is documented on official paper with dates and signatures. The first is a complaint, the second is a position. The second is about the decisions people make when they believe their consequences are controllable. Laura had made her decision calculating that either the marriage would recover and no one would need to know, or the marriage would end and she could handle the conditions from the version of events she chose to present. What she had not calculated was the scenario where the marriage ended, but I had the documentation organized, enough time to use it correctly, and a lawyer who knew exactly what to do with it. The third is more personal and harder to articulate. It has to do with what one does with the energy of anger. When I was on that emergency room stretcher with 3 fractured ribs and the confirmation that I had no coverage, the first response was rage. It was a completely reasonable response given the circumstances. What I chose to do with that rage was to turn it into methodology. Instead of using it to confront Laura immediately without complete information, I used it to build the most solid position possible for when the moment that mattered arrived. That choice to use the energy of anger to build instead of to destroy was the difference between a process that ended in 4 months with fair terms and what it could have been if I had acted on impulse. It is not always possible to make that choice. Sometimes the pain is too immediate to transform it into methodology, but when it is possible, it is worth more than what it costs. The hospital bill is paid. The insurance is in my name. The rest is what comes next. Comment: I really hope this story resonates with you the way it did with me. When someone crosses a line in a relationship, remembering your own worth becomes everything. I believe holding on to your self-respect helps you navigate those moments with clarity instead of chaos. Choosing to turn pain into a plan rather than letting it control you is a quiet kind of strength. It's important to set boundaries early so you don't lose pieces of yourself along the way. And when it's time to move forward, doing it with respect for everyone involved makes the healing feel more real. I've seen how taking responsibility for your own peace can transform the hardest chapters. You deserve to surround yourself with people who honor your trust. Learning to choose calm over conflict is one of the best gifts you can give yourself. I hope this encourages you to reflect on your own boundaries and keep building a life that feels safe and true to who you are. If you liked it, don't forget to leave a comment and support the channel by subscribing. See you in the upcoming stories.